Hey everybody, good evening. How you doing? It is Wednesday, June 11th, and it is closing arguments time in the Lori Vallow Daybell case. Welcome to Courtroom Insider. I'm Nate Eaton. So glad you're with me. If you're brand new here, if I somehow popped up on your YouTube feed or Facebook, welcome. Every night for the past 3 weeks almost, we've been analyzing and talking about what's happened during the Lori Vallow Daybell conspiracy to commit murder trial that's happening in Maricopa County, Arizona, downtown Phoenix. She is accused of conspiring to kill her former nephew-in-law, Brandon Boudreaux. The co-conspirators that the prosecutor has laid out in this case include her husband, Chad Daybell, who is currently on death row in Idaho, her brother, Alex Cox, who is dead, and her niece, Melanie Boudreaux, who has not been charged, but it has been made clear multiple times by the prosecutor, Trina Kay, that she is under multiple investigations. That was said today during court. Now the day has arrived for closing arguments, and we have a lot to talk about tonight. I'm so glad you're here. Here's what we've got on the agenda. Lori has filed new motions. Yes, in the middle of her trial, she's still filing motions. We have an FBI cast expert. When I say cast, it's not like a cast on a broken arm. It's something else. I'll explain it. Rule 20 denied. Lori asked the judge after the state rested to have her case dropped because she feels she should be acquitted and said the state did not prove their case. Closing arguments. I want to start singing Closing Time, that song. And the jury has the case. And now we have shout outs and questions. Obviously, we do not have a verdict. A verdict was not reached today. The jury went home about 15 minutes after they got the case. They are going to start fresh in the morning. And that is, so we could have a verdict tomorrow. So wherever you're watching from, let me know. And let me know when you think the verdict will be read Arizona time. When it will be read Arizona time. Read here in Arizona. Not the time you think they'll reach it, the time that it will be read. The judge has said we'll have a 20 to 25 minute warning, a heads up that the jury has reached the verdict, and that'll give us time to get in the courtroom if we're not there. He's told the parties to remain close to the courtroom. So with that being said, I want to talk really briefly about the new motions that Lori filed. She filed a motion saying that asking that Judge Green, so let me do some background. Judge Boreski is the judge in the case. She's asked 3 times to have him recused or removed. Judge Green is the superior judge. She heard a hearing on that matter, and she told Lori that you cannot file mid-trial for a new judge. You have to file 10 days before. Lori didn't do that. Lori now is asking that Judge Green get off. And another judge heard the case and denied Lori's motions. Lori talked about how it's dark in the courtroom, how she had a virus, needed water, was dehydrated or something. Anyway, her motions have been denied. So that's all we'll spend on that. You can go read them. They're very hard to read. They're handwritten, and it's very faint print. Let's get straight to the first witness and only witness today, the final witness, the first, last, and final only witness, Nick Balance. He is a CAST expert with the FBI. CAST stands for Cellular Analysis Survey Team. He's been a special agent with the FBI since 2016. Before that, he worked for the U.S. Marshal Service. This dude knows everything about cell phone tracking and Google data and all of that. He's testified in both Idaho trials before. We've heard him before. For those of you at home, you cannot see his face because he is an undercover agent and he does undercover work. He asked, or the prosecutor asked, that he not be shown. And so the judge granted that. So with the camera feed today and with the clips I'm about to play you, you won't see his face. He talked about how he was asked by Gilbert Police to go through the track phone and Google accounts belonging to Alex and belonging to Lori. He also did this with Chad. But he did this with Chad more on the Idaho side. So he basically did all the analysis with the cell phones and everything for all of the cases. Today in particular, he spoke about Gilbert and well, about this case. Yeah, about this case. And he went through the Homer J. Maximus iCloud account and the Lolly Time iCloud account, which belonged to Alex and Lori respectively. He talked about he did a presentation, a PowerPoint presentation that Trina Kay walked him through. Talked about the cell times. He talked about how cell towers have sectors on them. So if you look at a cell phone tower, it's split into 3 different sectors, and it beams out, you could say, or collects data. And the cell phone towers in more populated areas like downtown Phoenix, you're going to have a lot of them because there's more people. In remote areas, you're going to have less. And now they're actually designing cell phone towers to look like cactuses or other things to blend in so they're not as technology-ish, if that's a word. It's not a word. He told the court that every device has a MEID, mobile equipment identifier. It's kind of like a VIN, but for a phone. So your phone has a MEID, M-E-I-D, and they're able to take that MEID and send it out into the world and find out if you're on Verizon or AT&T or Sprint or T-Mobile or whatever the company is. And they're able to do that with track phones too. He testified that Alex Cox went into Walmart on September 25th of 2019. The Walmart in Idaho Falls, even though he and Lori were living in Rexburg, he was down in Idaho Falls and Lori was nearby.
A track phone was purchased at a Walmart at Idaho Falls, Idaho?
Yes, correct.
And when does it show that being purchased?
So it shows it being purchased on September the 25th, 2019 at approximately 7:10 p.m.
Okay. And does it show a store number of 5494?
Yes, ma'am, it does. I would expect to see a phone that is in close proximity to that line potentially still be on a sector, even if it's not within that parameter. All that to say that when I look at this particular graphic, based on my training and experience, I would say that tower and sector is consistent with providing coverage to that Walmart due to the close proximity.
So what we can say is that the 4652 number associated to Lori Vallow is utilizing a tower in the area of the Walmart within a couple minutes of that track phone, the 304 number being purchased at that Walmart.
Correct, 2 minutes prior.
And in fact, does one of her phone calls last about 10 minutes?
Yes, ma'am, correct.
So through the time of that purchase even?
Yes, ma'am. I would just point out that whenever, if you go back, sorry, to that page, whenever I'm looking at a tower interaction, whenever that phone is interacting with the network, we're looking at whenever that phone initiates that specific interaction. And so during that 10 minutes of time, I can't tell you specific to Verizon where that phone was located. I can only tell you at 7:08 and 31 seconds, it was utilizing that tower and sector. But let's say, for instance, that phone were to move out of the area, that would not be able to be determined by the records that I have.
That phone number that is being called at that time as well, are you familiar with that phone number?
I am, yes, ma'am.
The 480-266-8587. Whose phone number is that associated to?
I had that associated with Melanie Boudreau.
So at the time that Alex Cox's phone is in the Walmart, at the time that that track phone is being purchased, Lori Vallow is speaking with Melanie Boudreau using a cell tower in the area of that Walmart as well.
I wouldn't be able to say who was speaking with who. I could only say that the phone number 4652 received an incoming call from 8587 and then who those numbers are associated with.
So at the time that the phone associated to Lori Vallow is using a cell tower in the area of the Walmart, she is receiving a call from the phone associated to Melanie Boudreau.
Yes, ma'am.
Okay, you got all that? I kind of butted two sound bites together. His testimony got very technical. If you're into that, you should go listen to the whole thing. Very technical. Alex is buying the track phone at Walmart. Lori is nearby. Melanie Boudreau calls her as this is all happening. Could be coincidental, but not the way that the prosecutor was saying, laying it out. On September 30th at 7:38 p.m., Alex's phone goes to Lori's apartment and it does not move for 3 days until he's back from Arizona. The track phone then that he bought at that Walmart is activated and it moves, and the detective, the special agent, showed the phone moving from Rexburg to Mesa. On October 1st, the next day, Lori goes to that storage unit. We've talked about that. What we didn't know is that she went to that storage unit with Alex's phone. So she moved with it. It's like she carried it with her from the house to the storage unit. October 2nd is the morning of the shooting of Brandon Boudreaux, and Detective Special Agent Ballens was able to pull up the track phone data of what was happening that morning here in Arizona.
So from 7:02 to about 7:18, the Walmart track phone from Idaho Falls, Idaho, is using cell towers in the area of Melanie Boudreaux's residence.
Yes, ma'am, that's correct.
And then after 7:18, that cell phone, track phone from Walmart in Idaho Falls, Idaho, is now utilizing a cell tower closer to Brandon Boudreaux's residence.
Yes, ma'am.
Is this a continuation of that morning reflecting that Walmart track phone?
Yes, ma'am, it is.
Can you tell us what this map is showing us?
So this is showing the same thing, the 5998 phone on October 2nd between 7:22 and 7:24, utilizing two different towers, and specifically the tower more in the middle of the page, two different sectors on that tower, consistent with being in the area of Brandon Boudreaux's residence.
So from 7:22 to 7:24, we're seeing cell tower use from that Walmart track phone, consistent with it being in the area of Brandon Boudreaux's residence.
Yes, ma'am.
And this is the same cell phone we're talking about that has been associated to Alexander Cox's homerjmaximus@gmail.com Google account.
Yes, ma'am.
Okay, we have to be careful, and they have stressed this, is that when they they can't specifically say it is 100% sure Alex unless you have them on video talking on the phone at that same time. It's their device. So as I mentioned these things tonight, it's their devices. Melanie Boudreaux's device called Lori or whatever. And Chad's device called the track phone 3 times that morning between 8:39 and 9:16. The shooting was at 9:13. So, I should say he called or Alex called him. The devices called each other between 8:39 and 9:16 a.m. And that shooting was at 9:13. Then the phone that's associated to Alex, that track phone, quickly moves away from Brandon's area where the towers are and gradually moves its way to Utah and then to Idaho Falls. Now, Lori's phone activity. What was Lori doing? What was happening with her phone? Here's what the special agent said.
Between 8:50 and 9:45, there's 5 instances where that phone is on the network and utilizing a tower and sector consistent with providing coverage to Lori Vallow's apartment. And there's 2 outgoing calls, 3 incoming calls. There's 1 outgoing call to the number ending 8587, which was associated with Melanie Boudreaux. That call's a 35-minute call. And then there's 1 outgoing and 3 incomings with 0143. That number I had associated with Chad Daybell.
So since this is Arizona time, at 8:53, this would be before the shooting occurred in Arizona, if that occurred at 9:13.
Yes, ma'am, correct.
Okay. So prior to the shooting in Arizona, we have an outgoing call to the number associated to Chad Daybell.
Yes, ma'am, at 8:50.
And then an outgoing call associated to a phone for Melanie Boudreaux. And then an incoming call associated to the number for Chad Daybell at 9:01.
Yes, ma'am.
And then there is a break in time before there is an additional incoming call at 9:44 and 9:45, both of those from the phone associated to Chad Daybell.
Correct. And I would just point out that that 1 call at 8:53, that's an outbound call to the number associated with Melanie Boudreaux, is a 35-minute call. So it could have spanned a large portion of that time window.
So when we see the incoming call at 9:01, how does that work if she's on the phone outgoing?
I need to look at the specific call detail record, but that very well could just be call waiting to where both calls occurred during that same time window, but I wouldn't be able to answer that question with the records I have in front of me.
That call's just 2 minutes, 2:09.
Yes, ma'am.
Okay. So the phones were very busy that morning. Everybody in the group calling everybody else. And as I mentioned, the track phone made it back to Idaho the next day and was never used again. Was never touched again. Lori did have some follow-up questions for the special agent, mainly kind of clarifying how the technology works and what if you have 5 different devices and you use your one email associated with each device. Like I might have my laptop, my phone, my watch, whatever, an iPad. He said that when they pull the data, they're tagged differently. So he's able to pull up the phone, the laptop, the watch, and categorize it that way. She did also make the point that you're saying it's the device, not the actual human. And he said that's correct. We're talking about the device. And that was that. The final witness. And then the state rested. And the jury went to lunch. And after lunch, we came back and Lori asked to file a Rule 20. Now, this is a judgment of acquittal or unproven aggravator. This is pretty standard. They did this in Idaho. I've been in other hearings where they've done this before. Basically, after the close of evidence on either side, the court can enter a judgment of acquittal on any offense charged in an indictment, information, or complaint if there's no substantial evidence to support a conviction. So Lori basically said, there hasn't been enough evidence here. I'm asking you to drop it. Defense attorneys use it. They want it's kind of like a tool that they need to get on the record, maybe for appellate purposes or whatever. I need to ask some of my attorney friends, and maybe you know if you're watching and you're an attorney, if you've ever seen it granted. I've never seen it granted. But I want to play it out for you, what Lori said and how Trina K responded with her Rule 20 motion.
All right, we're back on the record. State of Arizona versus Daybell, Sierra 2022-001242. The parties are present. Ms. Daybell, go ahead.
With the Rule 20, Your Honor?
Yeah.
Okay. The court must enter a judgment of acquittal on any offense charged in an indictment if there is no substantial evidence to support a conviction. Conspiracy to commit first-degree murder requires the state prove that I, 1, agreed with another, in this case Alex, that one or more of us would engage in conduct that equaled first-degree murder, and 2, that I intended to promote or assist in the conduct. The only evidence that has been presented simply establishes that I have been seen on video placing items into a storage unit. A phone that is connected to me through an email made phone calls during this time frame, and a Google search relating to Gilbert, Arizona. None of this evidence establishes that I agreed with Alex Cox to engage in conduct that equals first degree. The state has the burden of establishing all elements of an offense have been committed, and thus there is not substantial evidence to support a conviction.
All right. Does the state want to respond for the record?
Sure. Looking at the evidence in the light most favorable to the state, there is substantial evidence for a jury to find the defendant guilty of conspiring with Alex Cox to commit first-degree murder of Brandon Boudreaux. In this case, in determining if a conspiracy existed, the jury can look at the fact that the defendant went with Alex Cox to buy the burner phone, that she loaned her Jeep to him to be used, that she rented a storage unit, that she Googled how to remove the rear seat, that she hid the tire and seat, and that she created an alibi for her brother by having those two phones interact while he was in Gilbert, Arizona.
All right. The standard is whether a reasonable juror could find the defendant guilty, whether there's substantial evidence that a reasonable juror could find the defendant guilty. The state has presented a compelling case that Alex Cox traveled to Gilbert, Arizona and attempted to kill Mr. Boudreaux. There's other circumstantial evidence that establishes that the defendant was aware of Mr. Cox's plans and facilitated those plans and assisted in those plans in several different ways. It's ordered denying the motion for Rule 20.
There you go. It was denied. I really like the way that Judge Boreski runs his courtroom. It is very efficient. He starts on time. He is no nonsense. I mean, he moves fast. And when the jurors then came out, Lori rested. I looked over at their faces when she said, "I rest," and none of them really, I didn't see much like, what? I didn't see much of a reaction. I'm sure in their heads they were thinking, what? Where's her defense? And they didn't get one. I've talked to jurors in the other cases with Lori, and they've all said, we wanted a defense. We wanted something. You want to make sense of it, or at least try to. And when there's nothing, what do you go with? Opening and closing statements, arguments are not evidence. It's just what's presented by the witnesses and the evidence. And the judge then read through their jury instructions very promptly. It's multiple pages. It's a packet. You can go watch the whole thing. I won't play it for you, but basically tells them what they need to decide when they go into the jury room. And then the final thing is closing arguments. Trina Kay's closing argument was around 45 minutes. She really laid it out. She put a timeline up on the screen and walked through everything and connected the dots. From the cell phone activity to the no tire on the Jeep to the license plate reader to the gunshot residue, all of it came together in this 45-minute summation of what we've listened to the past only 5 days. It feels like 5 weeks, but it's only 5 days. We're on day 5, really day 4. We're really in there 4 days. There was so much packed in there, 18 different witnesses. Quite a trial. I'm not going to play you all of Trina Kay's closing. We put it on our YouTube. You can go watch the whole thing. But I kind of butted together some of the highlights, how she started and then how she ended.
Who would want to kill you? That is a question that Officer Mary Ann Robb asked Brandon when she first arrived. That's a question that Detective Pillar asked Brandon when he spoke with him. Brandon Boudreau gave the exact same answer to both of these officers. He gave them 2 names. Lori Vallow, the woman seated over here, and Alexander Cox. He told them that he believed his shooting had something to do with an incident that occurred in Chandler in July of 2019, a couple months before this. He pointed them to that. He told them that Lori Vallow had lived in Texas and that the Jeep used in this shooting was from Texas. And then he told them what happened, how he had come home that morning. This Jeep was parked unusually close to his driveway, waiting. That he noticed there was no tire on the back. That he noticed that Texas license plate. That it was a 2-door Wrangler, and then he noticed that window go up. He saw the rifle come out. He saw what he believed was a silencer at the end, and then he heard and saw that bullet that hit the frame of his car, shattering the window right near his ear, causing that loud bang that he heard when that struck right near his head, mere inches away from him. The defendant has tried to explain away the evidence and questioning witnesses, asking if it's possible for a single piece of evidence to mean something other than what everyone knows it means. Is it possible that a Coke bottle broke in the street and one little shard stayed there right where Brandon Boudreau's Tesla was located when it was shot, a shard that looks just like the glass from his car in the driveway inside the seats? Is it possible that a tire iron made that bullet hole in the Tesla? Is it possible that the GSR in the Jeep is hairspray and fireworks? Is it possible that a Jeep with Texas plates belonged to someone else who wanted to kill Brandon? Is it possible that Alex was in Idaho and called her on October 2nd at 8:02 for those 24 minutes? Don't fall for the defendant's questions about what is possible when the evidence shows exactly what occurred. The only explanation when we look at all of the evidence together is that this defendant conspired with her brother and others to try to kill Brandon Boudreau. The state asks you to look at all of the evidence. not just the is it possibles, and find the defendant guilty of conspiracy to commit first-degree murder. Thank you.
I would encourage you to go watch the whole argument. And Trina brought up the defenses that Lori raised of, was it a gray Jeep? Was it a green Jeep, camo Jeep? And she showed the Jeep in different locations, and it looked like it could be a different color and based on the lighting and based on how it's viewed. She talked about some of the other things that Lori said, and yeah, go listen to it if you didn't get a chance to listen to it as it was happening. Then it was Lori's turn. And this was an interesting closing, and I'm going to play it for you. And I'd love to hear your thoughts in the comments.
When a family breaks apart, it is a tragedy, with the devastation far-reaching, affecting many people. I am not exempt from tragedy, none of us are. But what we learn from it is most important. Because of this experience, I've studied the law and the judicial system, and that knowledge will stay with me forever. When we experience tragedy, we can grow stronger from the experiences, and then those experiences are not all negative. You would think that often people in my position would feel defensive or angry, and from where I am standing, I understand that very well. But I don't feel any of those things. You have watched me under pressure, under scrutiny, and even under attack. And I have shown you that I'm not on any of those things.
I'm going to object to character evidence and testimony that's not in evidence.
Ms. Daybell, can I have you pull that microphone a little closer, please?
You can't be upset with people who are forced to look at your life from a distance or judge it through a lens that's being intentionally distorted or being at least very limited. Like the lens the state has shown you on this event. There's so much more going on that is not included to your view. The law prevents some of these things from being shared in trial.
I object, Your Honor, to improper.
Sustained.
You have seen opinions formed by strangers trying to put together a narrative. I have shown you that basically there is no defense to what a person did not do or did not participate in. Other than what you've seen, which is no evidence that I made an agreement to commit a crime, because no such evidence exists. So I'm not defensive. I'm not angry. Nobody has all the pieces to this puzzle. It is complex. Like most families, this is a complex issue. And like the state, I was not there. But there is no agreement, no plan, no game. I am no stranger to tragedy. The breaking up of a family is tragedy. On June 25th, 2019, Brandon Boudreau decided that I was responsible for his family tragedy. And I'm really sorry that he feels that way.
No, Your Honor, I'm going to object again to testimony.
All right. The jury is reminded that what is said in closing statements or closing arguments is not evidence, it is not testimony. The intent of the closing argument is for each side to argue what the evidence shows. Go ahead.
I did and have supported my niece Melanie when she suffered tragedy as a young child and during this terribly difficult time in 2019. We read the text from Brandon to me on June 25th, 2019, where he claims that he will never stop until he proves that I am responsible. Well, here we are, almost 6 years later, and I'm charged with conspiracy to commit first-degree murder. In order to have a conspiracy, 2 or more people have to make an agreement to commit a crime. There is no such agreement between me and my brother Alex, although I did love my brother Alex.
And I'm going to object again, Your Honor, to testifying.
Sustained.
There is no agreement that was shown to you between myself and Melanie Boudreau, although I love Melanie.
And I'm going to object again to testifying.
Sustained.
I cannot tell you what happened that day on October 2nd, 2019, because I was not there.
And I'm going to again object to testifying, and please strike everything the defendant has said.
All right. The defendant is admonished, you cannot argue things that were not admitted into evidence.
The prosecutor wasn't there. Law enforcement wasn't there. Only Brandon knows what happened before he called 911. Only Brandon said he will not stop. The fact that I supported Melanie in her time of need does not make me against Brandon. I had nothing to gain by Brandon being hurt. Brandon has worked with law enforcement for almost 6 years to make sure that I pay a consequence.
I'm going to object to misstating the evidence.
Sustained. The jury will determine what the evidence did and did not show.
Your job is to determine if I committed a crime. This crime. A conspiracy, an agreement, not cleaning out a garage, but an agreement to commit murder. You did not see an agreement. You did not hear an agreement. You heard Detective Duncan say that he had spent hundreds of hours going over my iCloud accounts. They have 19 years of my accounts. Text messages,
And I'm going to
calls.
object to misstates the evidence and no.
If there was an agreement.
Hold on. The objection sustained. The jury is reminded that they will determine what the evidence did and did not show. Go ahead.
If there was an agreement, they would have showed it to you. There is no agreement. We've all experienced tragedies in our lives, and naturally people want someone to blame, someone to pay a price. My brother is no longer here. We can't ask him about that day. There were things presented in this case that I did not know.
And I'm going to object again to testifying, Your Honor, and ask to strike.
Sustained.
Things that I saw, I thought,
And again, I'm going to already ask to strike.
All right. The defendant cannot testify to things that were not testified to from the witness stand.
because this is the theory the prosecutor wants you to see, it is limited. How can we say clearly when the law only allows for a skewed view of things? The devastation this family has gone through is the tragedy. After almost 6 years, it's time for healing. Thank you.
That's the closing argument. Very reminiscent of her statement in Idaho when she was sentenced. That she could have said at her sentencing, asking the judge to if she's found guilty. But that is very different than a closing argument. And you can see the judge was saying, you can tell him that the judge is over this. He's over it. And I don't think she was listening to a word he said. When he said sustained, I think she just kept reading. She was going to say what she was going to say. I was just thinking it would have been fascinating if on day one, I could have brought somebody with me that knew nothing about this case to sit in the courtroom with me every single day. And at the end of every day, be like, what are you thinking and what questions do you have? And not tell them anything. Like have them be the fake juror. And every day, just talk with them and bring them on Courtroom Insider. Maybe we'll do that with Koberger, the next trial or something, or Corey Richens, an upcoming trial. Have some, you all probably wouldn't qualify because you're watching this, but really find someone that can give up the time to come in and sit, because I'm sure they have I would have a million questions like, why didn't this woman put on a defense? Family tragedy. Where's Melanie? Where's Chad? Are they been charged? She mentioned their fourth husband, Charles. Yesterday, we saw briefly on the rental form in Idaho, JJ and Tylee's name. Does she have kids? I mean, there's got to be a million questions going through their head. Well, Trina had an opportunity to rebuttal what Lori said, and she was fired up. Here's how she rebutted what Lori said.
Defendant wants you to think that Brandon has it out for her. She has tried to insinuate that Brandon was involved with working with Detective Pillar for years just to get her. But what you heard was that Brandon has actually been working with law enforcement on multiple investigations, and that in fact Melanie Boudreau is a subject of multiple investigations. So again, as the defendant sits up here and tries to portray and paint a picture for you of her innocence and sadness and family tragedy, she again misrepresents what was told to you at trial. She tells you there was no plan, but she ignores the facts and the evidence of a very obvious long plan. A plan that started when she began, this defendant, Lori Vallow, meddling in Melanie and Brandon's marriage. And when that marriage was finally ending, this defendant continued to help her niece, Melanie. She continued to aid her. And what we see in every one of these bits of evidence is a core group of people. This defendant, her brother Alex, Melanie Boudreau, and Chad Daybell. The four of them working together. Do we need to have words of video? No, we do not. That is why there is that jury instruction on direct and circumstantial evidence, because you look at what is going on here, and it screams to you a conspiracy by this defendant, by Melanie Boudreau, by Alex Cox, and by Chad Daybell to kill Brandon Boudreau. Every action you see there, the defendant would like you to look at them individually and pretend that they don't all point to what happened on October 2nd. But everything they did leading up to then shows you a way to cover up and prepare for the murder of Brandon Boudreau. When we talk about a plan and this defendant's actions, the most obvious and screaming piece of information is this defendant holding on to her brother's phone for days, holding on to the 480-351-9120 number for days while her brother is gone, with her Jeep, without the rear tire, without the back seat, with a gun with him. That is part of the plan. That is the assisting, that is the promoting, that is the conspiracy that this defendant wants you to pretend doesn't exist. We don't need words. We have actions that are obvious, and they're done by this defendant and her co-conspirators. The state asks you to look at everything together, regardless of how many people want to cry up here, regardless of how many people want to try to testify. This is not evidence. What is evidence is what was presented to you in trial, and each piece of that tells you this defendant is guilty. And so I ask you to find her guilty of the conspiracy to commit murder against Brandon Boudreau. Thank you.
Whoa. Regardless of how many people want to cry up here or testify. Impactful, memorable. And with that, the jury walked out into their room. They stayed about 15 minutes. Maybe they appointed a four-person, we don't know. And then they left, and they told everybody, not them, but the court staff said that we'll be back tomorrow at 10 a.m. So we are on verdict watch. 10 a.m. Phoenix time tomorrow. The jury reports back to the courthouse. We will see if we have a verdict by lunch or if it will continue into the afternoon. If the verdict comes back guilty, there will be an aggravating phase, however, where they can say guilty and then Trina K can try to prove that there were dangerous elements of this crime, which could increase Lori's sentence. The jury would say, yes, there are. However, just like in Charles' case, Lori submitted to it. She waived that part. So we won't hear that part, most likely. And then the judge will set a sentencing date, probably within the next 30 to 60 days. And then we're done. If she's found not guilty, she will also be set a sentencing date because she was never sentenced for Charles's crime, that crime, and that will also be 30 to 60 days. So he's going to sentence them both around the same time or at the same time. That's where Brandon will get to speak. Kay Woodcock will get to speak on behalf of Charles. Other victims will get to speak. Lori will get to speak. And then we're done. Maybe. Because it sounds like, based on Trina Kay, there's this investigation with Melanie. She was not shy about naming her as a co-conspirator regularly today and throughout this trial. So we'll see if they decide to charge her and bring charges, or if she just remains under investigation. I do want to say too, she said repeatedly that Chad is a co-conspirator, but they told us, the Maricopa County Prosecutor's Office, in fact, let me find it. They told us that there was not, years ago, Maricopa County Prosecutor Chad Daybell, I'm just doing a quick Google. They told us that they did not think there would be enough evidence to indict him. So it was in July 8th of 2021. Prosecutors, it was a letter. Okay, here's the letter. Here we go. Let me make this big so you can read it. Maricopa County Attorney Nathan Duncan, Defendant Chad Daybell, an attorney, has reviewed the report and made the decision to decline prosecution on the following charges: conspiracy to commit murder first degree. This was in relation to Charles, 7/11/2019. Property release, no. Release for prosecution over. Do not release property. Co-defendant Lori Vallow. So they declined it, and it was Trina Kay who was the prosecutor, and Court TV. Oh, maybe they're sourcing us. Here we go. Prosecutors in Arizona have declined to charge Chad Daybell in connection to the death of Lori Vallow Daybell's fourth husband, Charles Vallow. In a letter from the Maricopa County Alistair Adele to Chandler Police, the reason for not charging is no reasonable likelihood of conviction. The decision isn't unexpected, since an affidavit of probable cause in Lori's case says there is no obvious communication between Chad and Lori to indicate he was directly involved in the planning of Charles' shooting. So, interesting. Chad called Alex on the track phone. Well, he did call Lori, but this is a different case. This was in regard to Charles. So there was no obvious communication between Chad and Lori about Charles' shooting till after the fact. So he's not going to be charged. Chad isn't, but do they charge Melanie? We'll see. That is the question. So, yeah, there we go. Let me, first of all, before we get to your shout outs and questions, because I know you have a lot of them. So yeah, stay tuned for tomorrow. We'll be here. I'll be here tomorrow night, following it as we always do. Teton Toyota has been amazing. They've given me this Teton Toyota Camry, which is awesome. It's so comfortable. Thank the heavens above that it has air conditioning. I think that after the length of this trial, it's gone so fast, I think I want to name it Speedy Trial. Or Speedy Toyota, Speedy Teton, something like that. You all had good names, but thanks to Teton Toyota, I'm looking forward to driving that car back home to Idaho here in a few days. And of course, thanks to newspapers.com. You all are amazing sending me your newspaper.com stories. They're sponsoring Courtroom Insider. They're making it possible for me to be here every day. I got a couple of stories I want to read to you about newspapers.com that you all have sent to me over the past little while, at least I should say. We have a story from Illinois. I have a fun newspapers.com story, and the viewers, if you want to share it, I currently have a subscription. The story I chose is 7 months before I was born back in 1981. During this time, jobs were very hard to come by. My father put an advertisement in the newspaper marketing himself in hopes to get hired, stating he will even pay for the job. Sort of a personal guarantee for potential employees, so to speak. He wanted to stand out in a crowded playing field. The newspaper liked the idea so much that they did a story on it and also stole his idea and started selling ads for job seekers. In the article, they printed, quote, "He began to worry, especially after learning he and his wife, Karen, were expecting their second child in October. I was that second child." The photo is my father at age 23. My son just turned 23 on May 23rd this year. I know that 23 is also a special number for Colby Ryan. Awesome. And then someone else sent me, you can go to newspapers.com and type in a name, and find stories about your relatives, your loved ones in the newspaper from 50, 60, 70 years ago. When this trial's over, I want to do a deep dive on like my grandpa, my grandparents, even my parents. Kristen emailed me and said, after watching the last Courtroom Insiders about newspaper.com story, I had to email you. Growing up, I heard a handful of times that my great-grandmother was found on the side of the road as a baby and raised by the family who found her. No one ever elaborated on the story. It was just more mentioning in passing. I never really took it seriously and thought it was similar to how siblings might tell each other how the younger sibling was found on the side of the road or found in the trash just to tease them. Fast forward to 2021, while doing family research, I came across this newspaper article and I about fell out of my chair. There it was, the proof that the story was in fact true. We do not know who her biological parents are. If it ever was found out, the information was never shared. Myself and other family members have taken DNA tests through Ancestry.com in hopes of long-lost family members can or will be found. I'm including the links to the newspaper articles on newspapers.com and the images, but please don't use my last name. So I won't share that with you, except the headline is, Who is Abandoned Baby? Amazing, amazing. So newspapers.com, solving questions and helping you find your own family research in this world of news. I love them. All right, I have a couple of shout outs here given to me on paper today in court. Nate, I have a super fan that's been following me in the case since the beginning. In recent weeks, her husband graduated from medical school in Michigan. She delivered twins and moved to Ohio. Wow, that is a busy few weeks. She hasn't had much time to follow this case as close as she'd like. That said, shout out to Tyler and Tatiana. Congrats on the twins. Yes. Good luck to you over the next few years. I have another note. Shout out to Tanya from Queen Creek. She's from England. She's got a wonderful accent. She wore her mugshot shirt to court today. We got a photo. Shout out to her two friends, Gene Webb in Wisconsin, and Ken Zach is a truck driver who listens from all over the United States. Ken and Tanya and Gene, thank you. By the way, we do a series called Working It where we try different jobs out. And I did before I came to the trial, I spent a couple hours with a truck driver and they put me in a semi and had me do the course. It was awesome. I think that maybe some days when the news is crazy, I just want to hop in a semi and drive it. And maybe we'll do Courtroom Insider or something. I don't know. You can watch it. I put it on my Facebook page. So thank you to all the truck drivers. Thank you. I got a note right before closings saying, we left you some Jolly Ranchers and a $20 bill so you and Jordan can go get a milkshake. And this is from the Facts with a Side of Tea. Facts with a Side of Tea. So you can decide what the fact and what the tea is. Anyway, I mentioned Apple Jolly Ranchers the other day. Thank you to Janice and the Facts with the Side of Tea. And for the $20, Jordan and I have said there's a milkshake place right by the courthouse, which the milkshakes are bigger than this microphone, like massive, with cookies stuffed in and brownies and candy bars. They're huge, and they're, I guess, like $20. And maybe we'll go get one. Okay, now let's go to your shout outs that Peggy collected. There's a lot of them here. Lucy H., Hope Robertson, Tia Desierna from Mexico. The pot stirs are here, and I have a picture. These are the ladies who met through Courtroom Insider through this trial. Let me try to get it to zoom in there. I hope it focuses. Some are from East Idaho. There we go. They all have mugshot shirts, which is amazing. So thanks to the pot stirs for watching, and don't stir the pot too much. Heather Daybell, remember in the trial in Idaho, Chad's father, I believe, said that she was a pot stirrer. Cat and Ham Stumbo from Pocatello. Patia Cafe from La Quinta, California. Quinta. Elaine Chester from Humid, Florida. Tanya from Queen Creek. We talked about her. Angela Jones from London. Scott Clements. Penny Claus from Illinois. Nita Smith and Kiora. I think I did that one last night, Peggy. Peggy just wants to be sure I get that one in. Here we go. Questions. Is the verdict tomorrow going to be on a 30-minute streaming delay? Good question. Glad you asked. No, 5-minute delay. I wish we could go fully live, but Judge Boreski wants a 5-minute delay in case anything happens. So here's how it will work tomorrow. We're going to start our live stream right at 9 o'clock. And then when the verdict is in, we will have about a 20-minute heads up, 20 to 25 minutes. I will tweet that out. I will put it on my Facebook. We'll put it on YouTube. And then we will cut over 5 minutes after court starts. We will go live with the verdict. After the verdict, stay with us because I'm going to run downstairs and we will, Brandon Boudreau will likely address the media. Other people might address the media. I don't know if Kay Woodcock will have anything to say. If Colby's there, we'll try to politely speak with some jurors if they want to speak. And then we'll have complete coverage for you tomorrow afternoon or morning or whenever. I don't know how long that coverage is going to be because honestly, it's 110 degrees outside, but rest assured, tomorrow night we'll do Courtroom Insider from here. And I was thinking, outside my window is the pool. I'm like, one night before I leave, maybe Friday night, I should do Courtroom Insider by the pool. Would you watch that? Is that too distracting? It might be weird because people might be swimming behind me, but Erica and I did one from the beach. We can do it from the pool. We'll see. What does Nate think of the reasoning is that Lori did not have any questions for Detective Hermosillo? That is a good question, Lieutenant Hermosillo. I think, excuse me, she knows that Hermosillo knows a lot. She never liked him. He was dark. I think he makes her nervous. I think she didn't even want to open the can of worms because remember, if she asked questions, Trina gets up to redirect. He was prepared for her questions. I think he was a little stunned that she didn't have any. I think we all kind of were, but not really. Kay Woodcock, she kind of did the same thing. She did ask questions, but yeah. Denise, I know this hasn't been proven, but who was driving the car? Are they saying Alex jumped out and took a shot and got back in and drove away? He didn't jump out. I think what they're saying is that he opened the back door of the Jeep. He was laying in wait. He fired, and then he turned around and jumped in the driver's seat and drove away. I think that's what they're saying. They haven't said anything more on if there was another driver in the car because his car continued to move and he was out of there. So I think he was just able to do it quickly. Is there air conditioning in the jail? I would hope so. I know that some of you wish there wasn't, but yes, in this area, there has to be air conditioning everywhere. Although I did live in Richmond, Virginia, where the jail in Richmond City did not have air conditioning or it was constantly breaking. And it was horrendous. And there were inmates that died like every summer. But yeah, they've got to have air conditioning. Tara says, why put the tire in the storage unit and not just in their garage? I was thinking about that. Based on what the testimony we heard today with the phone calls back and forth with Alex calling Chad after the attempted shooting, I would imagine the conversation could have gone something like, I shot the car, but he's driving. I didn't hit him. And then Chad is saying, oh crap, and calling Lori, and Melanie was on the call too. And he's saying he missed. And then they're worried because what if somehow they find Melanie in Idaho? Well, Melanie wasn't in Idaho. They find Lori in Idaho. They find Chad. What if somehow you worry? You go into worry mode of, oh no, are they going to be on our tail? Let's get rid of any and all the evidence that we have here. Let's go to the storage unit and drop off the tire in the seat. That's my idea because there were calls. And then that afternoon, Chad and Lori are at the storage unit. And then when Alex comes back, they're probably like, all right, we got to get that tire back on and we got to get the seat back in case anybody says anything. That's just my idea. I think it was probably a panic type of move to get it taken care of. If Melanie gets charged, will you cover the case? Yes, I will. I will. If she doesn't get charged, I'll cover it too. Nate, how does Lori get her highlights? I do not know. I don't know, unless her attorneys bring it to it. Someone told me that in the commissary, you can get some basic hair dye type stuff. Eileen asks that. Nate, have I secured an interview with Nancy Joe? Thank you, Stacy, for asking. I've been in communication with Nancy. We've spoken several times over the past, since Charles's trial. We've texted and talked. She's been at court every day. I hope she'll do an interview with me once. I'd love to talk with her, but we'll see. We'll see if she does. When she's ready, I don't want to push her. I don't want to push anybody. Same with Brandon. I hope Brandon does an interview with me. I've asked Trina Kay to do an interview. I think if that one happens, it will be after the sentencing. Hopefully not after the appeals, but I don't think that will be in the next few days. But yeah, I'd love to talk to anybody involved. Are Melanie and Lori allowed to communicate? And if they are, do they? They are allowed to communicate. Yes, Melanie is not in jail or anything, and she could set up an account to communicate with inmates. I don't know if they are. Hillary says, in the pictures of Alex's guns, were they able to determine what the distance was set at on the scope? No, we haven't heard anything about that. Is the storage unit the biggest scoop of your career? If not, what is? Lynn says. Oh, probably Hawaii. Hawaii, being in Hawaii was bigger than the storage unit. And the Hawaii one-on-one led to the storage unit, led to the interview with Melanie Gibb, led to other scoops along the way with this story. Yes, this story is the biggest. There's been other stories that have been big at the moment, but none that have lasted this long and been this intense and been this much interest. One day, maybe tomorrow or the next day, I'll tell you about my biggest regret in journalism where I stopped pursuing a story. I had a really big scoop. I stopped pursuing it, and then it turned into a massive story, and the Washington Post and all the national media were on it, and I had it first, and I kind of gave it up. And it led to a governor. It was a political scandal. I'll tell about that another time. Why is this case a conspiracy case and not an attempted murder case? I think conspiracy might be easier to prove. That they conspired rather than attempted, and it's all under one code. It's all under the murder code, so sentencing could be the same, 25 years to life. It's all the same there, and so they probably go with they charge with what they believe a jury can find guilty, and that's what they went with. Was the silencer ever found in Alex's stuff? There was a bunch of gun equipment, obviously, and ammunition. I don't know if there was a specific silencer found. Nate, have you talked to Melanie Pawlowski and ever done an interview with her? Yes, I have. I did it back in May of 2020, right before Mother's Day, and it was COVID, and so I couldn't travel to do it in person. We had to do it on Zoom, and Zoom was brand new. Her and Ian sat down, and we Zoomed, and there was technical problems. But anyway, that's on our page, on our YouTube. You can go watch the whole thing with the caveat that the children had not been found. Nobody knew where the kids were at that point. At least none of us did. And the situation has obviously changed a lot since then. So this interview is 5 years old. And I would love to talk to Melanie again. And I think I could be fair. And we have communicated over the years, not regularly, but, on and off. I think that's it for our questions tonight. Thank you all so much for watching. I appreciate it very much. There's where you can find me and keep up to date tomorrow. Facebook, X, Insta, and YouTube, where you are probably watching right now. We'll be back. Big day tomorrow. Thank you so much for watching. Again, I appreciate it. I'm Nate Eaton. This is Courtroom Insider. Take care. I'm still here. Have a good night, everybody. Now I will push this button and sign off. Bye.